Good evening, ladies and gentlemen, and welcome back to another program here on Legally Speaking. This evening we'll be talking about intestacy, what that means, and the consequences of dying without leaving a will. Now, that is essentially what intestacy means. Intestacy means that you died without making a will. It can also mean that you died making a will, but the will was not valid. And so if the will is not valid, you are treated as having died intestate. It could also be a situation where the will that you made was not exhaustive, in that you have certain property, but when you made the will, you did not contemplate all that you owned in that will. And so certain things were simply left out. Those things that were left out would fall to be administered under the laws governing intestacy unless there was a clause in there that captured the other things that were not specifically mentioned. And so you want to keep in mind that if you're going to make a will, for this reason that you seek legal advice, because you don't want to make a will only for it to be declared invalid at the end, or you did not contemplate certain things when making the will, and so that part of your estate is distributed according to the laws of intestacy. Now, the next thing that you want to keep in mind is that under intestacy, the beneficiaries must be able to produce some sort of certificate that evidences their relationship with the deceased. And so if you have a husband and your husband dies or your wife dies and they did not make a will, you have to be able to prove that that person was your spouse. And the way that you prove this is by producing an original copy of your marriage certificate, where you can say, I, Mary John, was married to Robert John, and you have your marriage certificate to evidence that you were married to that individual. Same for children. If your father or your mother dies, you must be able to produce an original copy of your birth certificate that evidences that that individual was your mother or your father. And I mention this specifically because there are a lot of people who do not have a name registered on their birth certificate under the slot there that has father. And so if you look at this birth certificate that I'm putting on the screen now, you would notice that on every birth certificate, below where your full name is recorded, there is a slot for mother and father. And you want to ensure that your father's name is included there, your mother's name is included there. Because if those sections on your birth certificate are left blank, the law essentially treats you as having no father or no mother, even if that individual was active and present in your life. And so if your father, and usually it's the father whose name is missing, mother's name are generally recorded in a birth certificate. I've never come across one where the mother's slot was empty. But father slots are not usually empty, but oftentimes it's not uncommon for you to come across a birth certificate and there's no name there under the father's slot. If the father is still alive, he can simply sign a declaration and have his name added by consent. So if you check your birth certificate, and I would urge you to go and check yours now, if that slot is there vacant now, you want to have that rectified as soon as possible. If your father is still alive, he can sign a declaration and have his name inserted there, and having a mother or father's name inserted there on your birth certificate automatically entitles you to a share in their estate if they did not leave a will or dispose of their assets in some other way. So having their names on your birth certificate is very, very important. What about circumstances where your mother or your father has already passed on? Unfortunately, the process is a lengthy, expensive process because you're going to have a declaration of paternity, or, well, usually it's paternity. A declaration of paternity after your father has died. And you would have to, number one, file a claim in the High Court and serve it on a beneficiary, a representative of his estate. And you're also going to have to produce evidence that while he was alive, he acknowledged and treated you as if he was your father. And so if your father is still alive, you want to ensure that this is done before he passes on, because it has consequences for your inheritance if they did not leave a will or dispose of their assets in some other way. And I put that qualification there because when people make a will, there's nothing that says they have to include you in their will. Even if you are a child, you can be dispossessed, if I could use that word here loosely. And so what I'm referring to here now is for those specific situations where your parent did not leave a will. They died intestate and you are automatically a beneficiary by virtue of having their name recorded on your birth certificate. So that's very, very important. So that's where we're going to begin, because you have to prove, you have to establish that relationship at the outset. Without that, and without a High Court order in your favor, you will not be included as a beneficiary under their estate, because these documents have to be lodged at the High Court office when the estate is being administered. And so what does the law say for those persons who die or have died without leaving a will? Because there is no will, or there is no valid will, or the will was not exhaustive, the law stipulates how that estate is going to be administered. And so, as I said in the last video, this is one of the reasons why you want to do proper estate planning, because if you don't do estate planning, the law will administer your estate for you. And the way it is done, it basically sets out a list, a comprehensive list of who will benefit in what order or priority and in what share. And so I'm going to go through that list with you now. And if at the end of that list there are no beneficiaries to receive what you left behind, then your estate would pass to the state, the crown. And so this is just one of the reasons why you want to ensure that you have planned your estate properly. And so first, if there's no will and you pass on, your spouse and your children are first in line. Now, first and foremost, if you die leaving behind a spouse but no children, so you are married but you never had any children, 1/2 of your estate would pass to your spouse, your husband or your wife. That's if you did not have any children. If you do have children, the position is different. 2/3 of your estate would pass to your children and 1/3 would pass to your surviving spouse. Now, that 2/3 will be divided equally between your children. So let's say, for instance, you have 5 children. The 2/3 would pass to your 5 children, and that 2/3 would be divided equally among all 5, and 1/3 would go to your spouse. Now, it's important for me to mention here that the law does not make any distinction between children born in wedlock and children born outside of wedlock. Used to be the case, that's not the case anymore. And so, whether or not your child or your children were born inside of the context of a marriage, it makes no difference. Your child is your child, whether they were born in wedlock or not. And so, in this context, there is no argument that outside children are not to benefit equally as children that were born inside the marriage. Now, what about a situation where you were never married but you have children? The law says your children are entitled to your entire estate. So everything that you have left behind would pass to your child if you have one child, or your children, and it would be shared equally to your children if you have no spouse. Now, if you have no spouse and no children, your estate would pass to your mother and father in equal shares. If your father and mother have already passed on at the time you die, it will pass on in the steps that I will go through now. First, brothers and sisters of the whole blood, which is to say, same mother, same father, in equal shares. And we go through this list in priority. And so, where one class exists, the following classes would not benefit. So, the first class, brothers and sisters of the whole blood, if there are none, then brothers and sisters of the half blood, half brother, half sister, would follow after. If there are no brothers and sisters at all, then your grandparents would benefit. If there are no grandparents, then the estate would pass to your uncles and aunts of the whole blood. And if there are none in this class, then uncles and aunts of the half blood. Now, as I mentioned before, if we go through this entire list and there are no beneficiaries in either of these classes, your estate would essentially belong to the state, to the crown. And so this is the order of priority. This is how estates are administered in circumstances where no will was made, or no valid will was made, or the will was not exhaustive, or there is some lapse of a gift under the will, which we will get to in a subsequent video. So now that you are aware and you have perhaps a mother or father who passed on, you can apply to administer their estate in the order that was just described. And you have an idea now how your estate would be administered if you fail to make a will or plan your estate, whether by making a will or by pursuing one of the other options, which we will discuss in the next video. So that's been it for today, and we'll continue this series in next week's video. Same time, same place. Want to thank my sponsor, Be Well Pharmacy, for sponsoring these videos, and I look forward to seeing you guys next week.